Good morning, friends. Today we are going to have the lecture. This is an introductory lecture on law and economics. This is lecture number one. We may be having a series of lecture on different aspects of law and economics. Especially in the introductory lecture, we try to introduce why we need to study law and economics and how it is connected to the idea called development, etc. So this is as a beginning point of a lecture. And by the way, this is a lecture which we try to offer for the course Law and Economics in the semester 4 of University of Kerala Economics Department for master's degree. Like this is an MA S4 course. Okay, and this is under the University of Kerala, which is taught in the Department of Economics, University of Kerala. So as part of this lecture inculcates many aspects of law and economics, both in the standard textbook format, and we also try to learn the subject a little bit on an Indian context. Why it is a little bit on Indian context? Because there is not much study had occurred or taken place on different aspects of law and economics in Indian context. Therefore, those studies are there, we will be reflecting upon, and other things we stick upon the larger international teaching, which is fortunately or unfortunately based on the United States, the US structure. Because why the US structure? Because we are more or less having similarity between United States and India. So this is in the outset I would like to say, and there are many more things which I'll keep commenting on. So this class is not about basically law, all right, and well, it's a sort about law, but it is also an analysis of law, because the law and economics is a literature which was started in early 1970s by the publication of Law and Economics by Posner as a teaching curricula in the University of Chicago and many other law schools in the United States. Before that, law and economics was taught especially by people like Aaron Director, who was one of the founder or the founder of the journal called Law and Economics. All right, so that was in the 1940s and 50s. Okay, he started teaching the antitrust law. Before that, also Henry Simon taught in the Chicago School the economic analysis of the law students. So this is what is actually the rough history where economists are building interest in legal issues. So from Henry Simons to Aaron Director, this was actually the trajectory of things. And later this became many more economists tried to evaluate and analyze many legal concepts, and then we formed a discipline, and in 1973 or so, Posner wrote the first book on law and economics, which is Economic Analysis of Law by Posner. Okay, or 74, that is roughly 73-74 period. And that is one of the fundamental books, which is normally, a very heavy book. And of course, it's a preliminary exercise. After that, there are many books, and many universities started adopting this discipline, and across the United States and Europe, and now in most of the world. This become a part of curriculum as one of the emerging field of economic analysis. So with this introduction, we also has to keep in mind, because this is actually this course is particularly I am giving to economic students, not a law student. Therefore, since it is not actually for law student, the most of the economic student, these concepts are new to them. Okay. So if it is a law student, then things would be different. For them, the approach would be completely different. So that is why I said this is not about the law per se, but how we have to think about it. So you are not in law school. By the way, the students are not in law school, and we students are our students are economic students, and largely I'm also not a lawyer. I'm an economist, but I have some training in this field. So it is not my job to make you a better lawyer. Therefore, it is so clear. So it is my job to teach you to think like an economist, even on a legal issue. So economics is not a bunch of facts. It is a set of tools in that sense. So what we are trying to build here is that you can apply the economic logic, that is economics as a tool, to understand the legal problem. So we can point this tool at just about anything. In this class, we will point them at a laws and a legal institution, but we are more interested in the tool than in the answers. All right. So what is law and economics? This is a fundamental question anybody has to ask. So most of the time we get an unsatisfying answer, like thinking about law like an economist or so. So microeconomics is about how people respond to incentive. We will be using microeconomics, including a little bit of game theory, to analyze laws and legal system, the incentive they create, and the actions and outcome they lead to. So this is what is roughly we are going to discuss. And thinking about the law like an economist, in that definition, often looks like a very narrow one, but it is different from thinking about law like a lawyer. But that part is clear. So suppose something has happened. Let's talk about an example. When a lawyer sees the case, the damage is already done. What is left? So assign blame, maybe punish someone, maybe move money around. This is interesting to the people involved, but it is not interesting to an economist. Economists are not actually doing it, because any accident happens, then in order to get the lawyer involved, the accident has to occur, or in order to have a law, or the law has to be enacted, and then only the role of lawyers there, and their interest lies upon there. So but an economist is actually talking about making of an efficient law by applying different logic economic tools. So what about the law is interesting to economists again. Now, before the incident happened, lots of decisions were made. Expectation, belief about what will happen after the fact influence these decisions, etc. So these decisions have an impact on outcomes, and these decisions therefore affect how much value is created or destroyed by society. So which is very interesting to economists. So that is why that sort of a law is interested to economists, and therefore the law, that sort of law should be analyzed by economists. So that is what is one way of looking at an economic analysis law do. So what about the law is interesting to economists? Let's look at an example. Something, so suppose if there is an accident, somebody drives a car, so they met an accident, so something happens. So after happening, only you can litigate or you sue the person. Then you will get as compensation, which can be just or fair or whatever. So this litigation and compensation, you require someone called the lawyer and the law. All right. This is the job of the lawyers and the law. But before that, in order to get into this thing, there is a priority to that is a decision making or an action per se. So whether the person has to drive the car today or not to drive the car today, or the person today, the day is actually a slippery day or a sunny day or whatever. That is all actually makes a person to decide whether they have to drive or ride the bicycle or not. So these are called the decisions. So when that decision is efficient, whether that decision is results in wrongdoing or something like that, has to be the concern of an economist. So that decision basically leads to this harm. So this is what the role of an economist comes in. So then that leads to the legal structure. So this is what is. So in a perfect world, then the later may not be existing, but the world is not so perfect. Therefore, the former decision is also important and the later is also important. That is why the understanding this law and analyzing law makes some sense. For example, earlier economist talks about, let's say, bargaining. Okay, they say that if it is a perfect world, then the perfect world means two individuals ready to buy and sell. All right, then if they are ready to buy and sell, they go and buy and sell. That's it. So this is making a sense that a perfect bargaining possible between these two guys, and they are going to do that. All right. So this is what is called a transaction. So in an ideal situation, there is nothing wrong in there, but this is actually silenced about many possible things which is required in the process of this bargaining. For example, the thing which I want to sell and the thing which you want to buy should have a sort of a right or kind of thing, because I should know that that is mine. If somebody else comes and says that that is his or hers, then things are going to be very difficult. Okay, so in the only two party, say Robinson Crusoe economy, there itself there is a problem, because if the Robinson Crusoe only exists in the island, then why the person keeps all the coconut? Because coconut is freely available, and when he want to pluck or collect, he can go and very well use it. But instead of that, what people assume that he keep that with his cave and or his shelter where he keeps, and then Friday arrives, then he makes a bargain. So that means it is actually forms with an expectation somebody is going to, or some mishaps happens. So based on that only you make such decision, which is pretty good, but it is actually relaxed certain fundamental characteristics of the economic analysis. However, we are not going to dwell that into the details right now, because now expectation itself is act as a norm as far as this person is concerned. So then that is makes the person to keep this product with him, or the produce which is nature's produce with him. So that makes actually the product valuable, and that makes him to have a sort of advantage. The other point is actually maybe because Robinson Crusoe had entered the island first, therefore this is what is called the first possession right of the island and property. Then he can bargain with it. So we will be discussing that itself is actually a right consciousness which is a priori to a decision or bargaining. So now two people go simply and do bargaining is not actually the case or the sentiments which we have to talk. Preceding to this process itself, there would be a legal sentiments or the norms driven sentiments, which is what Adam Smith called the moral sentiments, which has to precede the economic transaction in that sense. So with this note, I would like to say that there are a lot of things which influence such decisions. So it is mutually and interlinked each other. Therefore, the law and economics makes a perfect blend of an analysis of this kind. So what we have from a textbook point of view, let us look into David Friedman's book, Law's Order. So in page 8, there is a state. You live in a state where the most severe criminal punishment is life imprisonment. Again, this is also a kind of an example which makes us to think like an economist. All right. Someone proposes that since armed robbery is a very serious crime, armed robbery should get life sentence. All right. So a constitutional lawyer asks whether that is consistent with the prohibition on cruel and unusual punishment. Whereas a legal philosopher asks whether it is just. An economist point out that if the punishment for armed robbery and for armed robbery plus murder are the same, then the additional punishment for the murder is basically zero. So what is called the marginal punishment. So if that is zero, then the person is having always, those who have a tendency to rob, they also has the tendency to kill that person, because the difference between robbing and the killing the person is one and the same in that sense. So, and ask whether you really want to make it in the interest of the robbers to murder their victim. So in that context, we ask that, how can we though it is very severe, somebody a punishment of this kind. So the extent of punishment now being relaxed, because you make that, every point there is an additional point to be additional point yet to come. So from this angle, we can actually discuss and we can reframe a lot of things in the real world context. So this is what is actually an economist way of thinking. So that will be our focus in this class. So what we are going to do is that, however, that is not the whole point which we are going to do also. There are many law and stories regarding that are involved, and there are many things which we are going to discuss in the coming lectures. Most of them are areas law. We will cover is property law. We're also going to cover contract, tort, legal process, criminal law, and some other topics which of our interest. So of course these lectures are going to be little tough lectures. Of course it is not because of the thing, because for the regular thinking this is going to be a little difficult to abstract, otherwise not a big deal. So it is a hard class, and sometimes you feel that since it is not an interactive lecture, you also feel sometimes it's dry, because if it is an interactive one, it would be more easier to communicate many things. So but that problem I would be solving engaging with the examples and all. So thinking about things like an economist can be hard. This way of thinking comes naturally to some people, but not all other people. Like I said, the marginal punishment and all. Many people may think, some people may think, and many are not actually interested. Because I keep shooting the question that how many of us are interested in giving capital punishment or supports capital punishment. From an economist's point of view, I would never agree with it. Capital punishment, because it is not constitutionally right, because there are many other things which has to be, and so things are actually very difficult, and it is not necessarily so straight to everyone at every point. So if you don't get it, you can't get by memorizing a bunch of facts. Someone in this class will get a C who is never got a C before. So this is a caution as far as the class is concerned. So I'm not actually worried about whether you get a C or a D or A. But the most important thing is that you have to follow the class, which is essentially going to give you a lot of insight to understand the things which you never thought of. So, not trying to scare everyone. I'll just rather say this now that after the first midterm, you also feel uncomfortable if if you don't really follow the class. Plan for the rest of the lecture is a bit history and some examples. So let us talk about the history. Why I'm going to focus the history of common and civil law, because these are the two legal traditions which is practiced most of the country in the world. And there are other laws also we will eventually get to know after the analysis of common and civil law history. And then we will go and deal with the example, which is the social norms or legality, the evolution of legality in that context. So, two great Western legal traditions of the last millennia is common law and civil law. The common law is known as English law. A civil law is called the Napoleonic law. So a little confusing, because civil law also refers to a branch of law within Indian and US system or in the common law system itself. Civil law is also comes under the common law. So people may be thinking that civil law is actually a subset of that. That civil law is completely different. That is dealing with the individual to individual problems, cases basically, like property, contract breach, tortious case, etc. With that of the civil law tradition is a legal tradition which is actually practiced in the continental Europe largely and the Hispanic world. Most of the Hispanic and the Latin, that is in Latin America and the European continental Europe and some part of Africa, this civil law tradition is strictly followed, and it's part of Asia. So we will see that map and which country is having what kind of legal system. So criminal law is deliberate illegal act punished by government. So whereas the civil law, lawsuit brought by one private party against the other. And this is also a subset of the common law. All right, that is within the common law, because William Blackstone called it as right and wrong. So the right and wrong is the civil and criminal procedure's origin, which was formed in the English common law, which is having the subset like criminal law as well as civil law, where the civil law is a lawsuit brought by one party against the other party, private party against the other private party. Whereas criminal laws are actually the lawsuit brought by the state vis-a-vis or the government vis-a-vis the defendant. Alright, so we will touch in both, but most of the class will focus on civil law issues within both common law and civil law traditions. So, common law, that is originated in 12th century England under King Henry II. That is, judges rule according to local norms and customs. So go out and find the law as it's being practiced. So he asked to do that, and now new laws enacted by legislature. Judges interpreted law relying heavily on precedents. So each decision is precedent for future cases. So common law, originally rooted in common practices, can be changed by legislation, evolves with each new cases. So still basis for legal system in many English speaking countries including India. So the civil law tradition persists today in most of the Western Europe, Central and South America, part of Asia. Originated following French Revolution, that is, judges like king were viewed as corrupt and worthless. So Napoleon commissioned a group of legal scholars to draft a new set of law, the Napoleonic Code or Code Napoleon. So less reliance on historical norms and precedents. That is what precedents and historical norms were treated as less reliable, and they try to attempt to explicitly spell out the law starting from blank slate. So legal argument appeals directly to written law and commentary. So this is what is actually the function of this thing. So basis of modern legal system, this is a map of the world. This is a bit older, is it 3-4 years back. So Wikimedia Commons, Washington Post Worldview Law. So this is what is actually the frame look like. So look at the red line, common law. This is most of the Canada, US, India, Pakistan, Nepal, Bangladesh. Sorry, um, Myanmar, where the military kind of things exist, but irrespective of that, actually most of this country, a part of the world is actually following this. Australia, New Guinea, and New Zealand, all this is follows a kind of common law, whereas in Papua Island and part of Canada, that is Quebec region, part of this Central and South America, most of the Central and South America, and I think most of the um, African and Asian country follow civil law. Whereas some countries like they have a mixed law, so common and so for example the Quebec region of Canada, then South Africa, then other countries, they do have common and civil law. Whereas some countries having religious law, for example, Saudi Arabia, Yemen, UAE, Iran, then Afghanistan, all these countries having Morocco, then all these countries, in fact, having a sort of religious in Bangladesh, for example, in Asia, these countries are having religious law, Sharia law, or whatever religious things are actually um, gives. So this is particularly important, and then certain countries like Mongolia and all, they follow customary laws. So in the map, if you look, there's a lot of countries which practices different varieties of legal system. Now, comparing the common law and civil law tradition, this is very quick way of understanding. This is maybe useful for you, test and all examination. Some quick points like civil law, difference between civil and common law. So civil law originated in 18th century, whereas common law originated in 12th century England. Civil law in 18th century France, persisted in Western Europe and lots of other places, in the US, UK, English speaking in India and other part. So the civil law is based on ancient sources and pure reason. That is, group of scholars with blank slate. The judge, in fact, every case has been, tried by judge. Judge used to ask and reasoned and analyze the case, and then they give a sort of verdict. Whereas in the common law, it is based on existing practice and social norm and based on the precedence of the earlier case, etc. So it is a cost reference based case law. This is what is called case law based one. Whereas in civil law, legal arguments appeal to interpretation of law itself and to commentary which clarifies its meaning. Whereas common law argument focus on legal precedent, so law evolves as new precedents are set. So this is what is actually the difference. So immediately you can say that the civil law and civil law and the common law is, one is spontaneous order and the other one is a planned order. The common law is not shaped by a single mind but a bottom-up aggregation of many individual plans. Whereas civil law lay down at a particular time mean to be more static. This is what they say, but I think civil law is always treat the case with the blank and with the diversity of each case, and it is some way many scholars used to argue that which law is efficient, whether the civil law is efficient or this criminal law is. There are many Hughes and Snyder, for example, they talked about the efficiency of the civil law with the common law. Some say that if Hanben Schaeffer's work says that civil law is more efficient than common law. So there are many people, the scholars say that in different aspect. which or one tradition is better than the other. But I'm not this lecture, at least we are not judgmental saying that which one is better. Because that is depends on different cases and case to case, and the problem which they deal with. So some problem from in my mind, common law is much better than civil law, and some place civil law is much better than common laws practice in the real world. So in that sense also there are mixed views of which one is good and which one is bad. So another example of how common law develops and responds to local practice is a very interesting one. So let's talk about an example which is called whaling, which was developed as one of the industry in the 17th, 18th and 19th century. Okay, a nice example of how the common law respond to local norms and practice. So question, that is, who owns a dead whale? So you know that 700s to 800s whale hunting for oil, bone, other valuable products, and it is a big business in the international market, in international economy. A captured whale could be worth 3-4 times a typical family's yearly income. So a conflict would sometimes arise over ownership. So this is the outset. What is the problem? The question is that if it frequently happens that when several ships are cruising in company, because whale is a big animal like a mammal in the sea, it is, I think, an average blue whale is size of almost 32. Average, blue whale is almost like 30 plus elephant size. So you can imagine the size of this particular mammal. So it is very difficult to catch that mammal alone in the earlier time, where you just go with your yachts, or you hunting with your yacht or a small boat or something like that. So that is why this question frequently happens. That is, a whale may be struck by one vessel, then escape and be finally killed and captured by another vessel. Then who owns the whale? So this is the question. Or after a weary and perilous chase and capture of a whale, the body may get loose from the ship by reason of a violent storm. So there are other possibilities: a drifting far away to leeward be retaken by a second whaler, who in a calm snugly tow it alongside without risk of life or line. So who is going to own this? Thus the most vexatious and violent dispute would often arise between fishermen. The same is actually a quote from Melville's Moby Dick. Alright, so Robert Ellickson, a fantastic law and economist who had in fact done quite a good amount of work in this aspect. So he had a paper, that is hypothesis of wealth maximization, evidence from whaling industry. In his paper, he examined 12 British and American court cases where ownership of dead whales was contested. In each case, the local whaling industry had established norm of determining ownership. Norms offered from place to place, but were well suited to that of environment. So in each case, the common law court ruled in accordance with the existing norm. So most of the people say that the common law precedents, if you rely on precedents, there is an inconsistency in that. Inconsistency is part of the norm as well as the situation which it was evolved. So the first, we will discuss that with an example after this thing. So with the second example, So the first norm in the whaling industry was evolved was fast fish, loose fish. So established by British whalers in Greenland fishery, prey were right whales. Hunting was done by harpoons attached to whaling boat by rope. This is the kind of a picturization of the same. And a harpooned whale attached to a boat was fast fish. But there is a possibility of losing your life in that process. So see, But a harpooned whale attached to the boat was a fast fish and belongs to the boat it was attached. So if the whale broke free or had not yet been harpooned, it was a loose fish and other ships were free to pursue it. So this is the first norm. A different norm was developed, which is called iron hold the whale. So used in fishery where sperm whales were. Sperm whales are even bigger and faster one. Sperm whales swim faster, dive deeper, fight harder. So this is a sperm whale and hunted with the harpoons attached to rocks. So sperm whale swims in schools. So again, it is actually a group of whale like their family and all. Maybe a group of male, female, and their packs. They move. So the whale swims in schools. So the rules that developed iron holds the whale develops because of this thing. Because if you harpoon a whale first, you own it. As long as you remain in fresh pursuit. Alright, so this is the thing. There is a clear trade-off between the two rules. That is, iron holds the whale is more complicated and ambiguous, whereas the fast fish, loose fish is simpler, bright line rule. Now, but it wouldn't work well with the sperm whale. That is because it fights and you will be dead and you won't get it also. So trade-off between simpler rule versus better incentive rule is emerged in that context. Simpler rule is easy to implement and fewer dispute arises, but more complicated rule might be able to provide better incentive and better kind of litigation or whatever dispute. So again a third norm developed where finback whales were hunted. So finback whales, extremely fast swimming whales in 19th century whalers hunted them with bomb lances. See, this is 19th century after this bomb was dynamite was introduced. So they used this thing bomb lances to kill these whales. So dead finback would swing and wash up because it is so fast swimmer. So even if it is a dead, because of the swimming fast and they go down deep, and it may be washed away in some other shore, wash up on shore days later again. So norm developed that original killer and the finder of the whale would split it. So again, which reached in 1881 case, it was ruled in that way. So what is the conclusion from Ellickson? Ellickson emphasizes in each location norms developed which were well suited to that particular environment and that particular kind of pursuit which they had. So my point that in every case the judge ruled in accordance with the local customs. For example, in Indian context, let us talk about the hawkers and vendors. Recently Supreme Court, recent means in 2011, Supreme Court had given or instructed the state government to develop a local specific law to do the same business, because the hawkers and vendors dispute standing dispute in the courts in India, because in the early 1960s and 70s many dispute were arised due to this hawkers and hawking and vending in the wayside. All right, so what is the problem in the wayside vending or hawking? You have a constitutional right to do business. At the same time, you have also right to free mobility. Now, what happened is that the private interest of the people, that is by selling, it is actually serves the private interest of that seller, but that is actually infringes the right of a private person to move freely. So this is actually, in fact, created a sort of ruckus, and often the police and the administration raided these hawkers and vendors very frequently. And this was a very common practice in the 60s, 70s, 80s, and there are so many litigation in the law from lower court to the Supreme Court. So many verdicts had actually often given a right to hawkers in one instance, then the other instance it is given to the priority to the mover, like people people's mobility. So this become a big problem, and for example, in the Bombay High Court, in many verdict they said hawkers have right, and then after the litigation again they lost. Again, same the case with the Madras High Court. Same is the case with the Allahabad High Court and Delhi High Court. So in most of these places, this problem is kept evolving. Like one point you say that they can do, and at the same time you can say that in some other context they cannot do. Though all this is based on the precedents and other things, but still this inconsistencies evolves. So the same is actually the case with the earlier example which we had discussed. Therefore, what is the most important thing is, even in the common law, the precedents, it is also influenced by the conditions of or the strength and validity of the evidence which they argue for. Okay, so that is how a law is being developed. And now, as a final conclusion of this problem, in 2011, Supreme Court said though both fundamental rights are to be has to be protected, and now it is the state, up to the state to make an appropriate mechanism to have a clear-cut legislation to do what is the extent and what are the procedure which they have to follow in enhancing business, as well as without curtailing the mobility of the common people. So that is how law evolves, and the Supreme Court asked the legal system, the state to make law, legislate their own law, which suits, which accommodate this kind of thing. To connect it to more modern concern, I found a legal brief using same principle to determine ownership of souvenir baseball. So ownership of Barry Bonds' 73rd home run ball was disputed. So Alex Papo had the ball in his glove first, but lost it in the scrum. Patrick Hayashi ended up with the ball. Both wanted it. See, Patrick Hayashi and scrum. Alright, so the brief perfectly captures the essence of the common law system. Simply put, the court should adopt a rule of first possession. Now the question is that the rule of first possession is somebody who got the ball but they lost it. Then somebody at the end got somebody, and he's anti Patrick Hayashi. At the end, he's had the. So things can actually have different forms, and it appears differently. To put it in a very simple sense, the court should adopt a rule of first possession for baseball that recognize the long-standing customs and practice of baseball fans who, for more than 70 years, have competed to catch and gain title to baseballs that leave the field of play. So Barry Gray, a report and recommendation on the law of capture into first possession. With these principles in mind, the court should define the law of first possession of baseball by answering two questions. First, what is the custom, practice, and understanding of the baseball fans about first possession and title to baseball that enters the stands? Second, should the rule as practiced in the stands be modified to minimize the risk of violence, misconduct, and tortious behavior? So these two questions are very important in the Brian Gray report and recommendation of the law capture the first possession case. So in the end, the ball was sold. What happened? So you may be having curiosity. So in the end, what happened is that the ball was auctioned, and for $450,000 proceeds were split between 50-50. So this is what has actually happens. So in that context, what we would like to say that the law and things are actually evolves, and that need to be evaluated, and then we will see that which one is better suited for whom, etc. So this is what is in a nutshell the law and economics lecture which we are going to proceed with. And the next lecture we will talk about other tools and mechanisms and norms, so concepts, etc. which deals with this system of analysis. With this note, let me conclude today's lecture. So I hope all of you understand or all of you enjoyed the lecture. Thank you so much for your very patient listening, and we will have a nice lecture ahead. Thanks once again. Thank you so much.